Hello, my name's Olurotimi Osha. Today is April the 11th, 2026. This is still Stress Awareness Month and Autism Awareness Month as well. So those two things deal with mental health. Of course, Mental Health Awareness Month is in May next month. But as I've mentioned, in light of the clamor for the invocation of the 25th Amendment for the removal of President Donald Trump, uh, due to questions concerning his mental acuity, or I don't know if the accusations are insanity or whatever. Insanity is no longer a term. There has to be some kind of diagnosis. I've done videos explaining this before. There's got to be some kind of diagnosis, right? You just don't use ad hominems, and libel and slander and say, well, the president of the United States is crazy or insane, despite his posts and his tweets, right, and his threats, his threats to annihilate an entire civilization. That is, of course, it is beyond the pale, but there's a process. But in any event, what I'm doing is I'm discussing a mental health law. And this case I'm going to discuss today is very important. Earlier cases I've dealt with, I've done a case that talked about standards, right? Like Addington versus Texas, that deals with the burden of proof that gave established the standard to be used as clear and convincing evidence, right? Clear and convincing evidence. So now this has to do with uh, the length of time, right? That one can't be uh, committed to a psychiatric hospital or confined for an indefinite period solely because they've been found incompetent to stand trial. Now, I'm not going to editorialize and go into my personal matter. I've done videos in about the public corruption under Judge James Bonifant, how he abuses competency to stand trial orders, and that's something I've experienced. I've done videos talking about that. But in this case, I'm just going to focus on this particular landmark case. It's called Jackson versus Indiana. It went all the way to the Supreme Court. It was presented to the Supreme Court in November 1971. But it wasn't decided. It was argued at the Supreme Court in November 1971, but it wasn't decided until June 7, 1972. So you see, there's quite a long, delay. The legal process, can be a little bit slow. Um, and the presiding Chief Justice then was Warren E. Berger. It was him. He's been on the other cases as well that I discussed. And so you see, mental health became a huge issue before the courts in the 1970s. And you notice that these are 1970s cases. Um, Now, this court was unanimous. Importantly, the legendary Thurgood Marshall was on the Supreme Court then. Two people did not consider or vote in the court's decision. So the court was unanimous, but two people did not never deliberated or voted. That's William Rehnquist, one of them. William Rehnquist, of course, later on would become Chief Justice, right? He was the Chief Justice before the incumbent Chief Justice. That's Justice John Roberts. So William Rehnquist and who was the other? Justice Powell, right? Justice Lewis Powell. So those two justices were not in the deliberation and did not vote. But other than that, everybody else were unanimous. So um, let me get into the facts, right? I'll get into the facts. Um, so the 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 plaintiff. So the case is Jackson versus Indiana, and it went all the way to the Supreme Court, writ of certiorari. The person who argued the case before the Supreme Court was a guy called Frank Spencer, and he was a remarkable, accomplished lawyer in the state of Indiana. He'd been a prosecutor at Marion County at some point, and then he was assistant deputy attorney general for the state of Indiana. But the person, and the person who was the plaintiff, he was representing a guy called Jackson. Jackson was a deaf mute, right? He was a deaf mute. He could not read, he could not write, he could not communicate. And so, but um, he had been charged with, he had 2 counts of robbery, 2 counts of robbery. And the judge decided that, okay, he should have some competency evaluations. So a reason a judge orders a competency evaluation in a criminal case is consistent with the Sixth Amendment, right? Under the Sixth Amendment, uh, a defendant, the accused, is entitled to a fair trial, right? So, in order for it to be fair, the judge wants to ensure that the accused understands their charges, they know their charges. And under the Sixth Amendment as well, the accused, they're supposed to know their charges, right? They have a right to know their charges, what they're being charged with. And they're entitled to a fair trial as well. They're entitled to a fair trial. So, um, so it's under that fairness, right, that the judge, that the judge decides that, okay, he wants to ensure that the defendant, at least they're able to understand their charges, and they should, and the way he can determine this is to for them to undergo a competency evaluation. um and the competency evaluation, there are just 3 things, typically, that the court is trying to establish, right? That the defendant understands their charges, consistent with the Sixth Amendment, right? Understands their charges, and they understand courtroom proceedings, right? So they know what's going on in the courtroom, they know how to conduct themselves, they know who is going to be defending them, they know the process, they know what they're pleading to, what they're if what their plea is, if they're pleading, if they're saying that, well, they're guilty or not guilty, they know who's defending them in things like that. So they understand courtroom proceedings. They know how not to act, how not to react in the court. They know when to show up for their trial. And they know what the outcome's going to be. So that's them understanding courtroom proceedings. And then the third thing, though, is that they are able to work with their lawyer in a calm way, and contribute to their defense, right, in a meaningful manner. So those are the 3 things that a competency evaluation wants to determine. Somehow he failed the competency evaluation, and the evaluators determined that he was feeble-minded, right? He was feeble-minded. Now, there are conditions that would typically trigger a competency evaluation. 2 things. One, uh, in the state of Maryland, they say mental retardation. That's what they use, mental retardation. Uh, to saying one's mentally retarded is no longer fashionable, right? It's a pejorative. So in this particular case, it was called feeble-mindedness, feeble-mindedness. So that's equivalent of being mentally retarded, right? So they have a subpar intelligence, right? They have a very low intelligence level, right? So feeble-mindedness. The other thing is a mental illness. They have a severe mental illness, and either one of these 2 things, or a combination of both of them, makes it difficult for them to understand those 3 elements of competency, as I stated. That's understanding their charges, knowing what courtroom proceedings are, and ability to work with their lawyer so that they can provide a meaningful defense, right? So, in the case of Jackson, right, he was deemed feeble-minded, and of course, the fact that he was a deaf mute, he could neither hear nor speak, and he could not, he was illiterate, he couldn't read or write, and he couldn't communicate. So, he was committed by the judge, but there was testimony given already. They said, well, they didn't have the facilities to treat this person and restore him to competency, right? The charges weren't dismissed. So typically, the process is that, okay, if somebody is found incompetent to stand trial, so he was found incompetent to stand trial, and typically, if someone's found incompetent to stand trial, they can either send them, sometimes, if it's a minor charge, if the offense is a minor, right, if they're trivial, they're not severe, right, if they're misdemeanors, right, then the charges can be dropped in exchange. That So when they're dropped, it's called nolle prost, right? They're nolle prost. Nolle prost is the short term of the Latin nolle prosequi. Nolle prosequi means the prosecutor has decided not to proceed, right? The prosecutor is deciding not to proceed with the prosecution. So essentially, they're dropping the charges. So they normally do that in exchange for something, right? They will decide to drop the charges if the defendant agrees to go and take treatment, some kind of treatment, then they'll drop the charges. The alternative is if it's not nolly prost, or they'll take some kind of plea bargain. They can have a plea bargain, agreement, and there are different types of plea bargain offers that the prosecutor can make. Alternatively, but it suspends the trial. It suspends the case, right? So the judge can decide, well, okay, he's going to commit them temporarily to a psychiatric hospital, temporarily, just because of this, because they're incompetent to stand trial, to receive treatment to be cured, right? So they can be restored to competency, and then the case can proceed. But while they're found incompetent to stand trial, the case is suspended, right? It's on hold. However, in the case of Jackson, there was testimony that was given in court that, look, this guy, Indiana didn't have the facilities to restore Jackson to competency. Nevertheless, the charges weren't dropped, and the judge just committed him to a psychiatric hospital, right? So he was committed indefinitely to a psychiatric hospital. And so because he was committed indefinitely to a psychiatric hospital, the charges weren't dropped. They were just suspended, and he wasn't receiving treatment. So because he was also feeble-minded, the other thing is, as he was feeble-minded, the reason they committed it instead of giving him outpatient care, because the evaluators determined that he was incapable of caring for himself, right? He couldn't care for himself, right? And so they committed him to a psychiatric hospital. And so in any event, what he did was he decided to file an appeal, right? So he filed an appeal. He got some attorneys got interested in him. One of them, as I said, being Frank Spencer. They filed an appeal saying, well, committing the defendant, that's Jackson, indefinitely violated his due process rights. That's the 14th Amendment, and it also would constitute cruel and unusual punishment. That's the Eighth Amendment, right? Eighth Amendment prevents excessive bills and fines. If someone's accused of a crime, right, because they're just accused, right? It's alleged, they haven't been convicted of a crime yet. That's it. So it prevents excessive bill and fines and cruel and unusual punishment, right? We normally think of the Eighth Amendment, the cruel and unusual punishment part, as after conviction, right? After conviction. So you can't torture somebody after they've been found guilty. Our legal system, doesn't allow that. That would be cruel and unusual punishment. However, there have been instances where the courts have determined that lengthy, indefinite pretrial detentions constitute cruel and unusual punishment, because if somebody's just waiting for their trial, they haven't been convicted, but they're locked up in jail for a long time, indefinitely. It's like it amounts to some kind of life sentence, and that was what the attorney supporting Jackson was arguing, that okay, that this guy has not been convicted of any crime. He hasn't had a trial. He hasn't been convicted, but they're committing him indefinitely to a psychiatric hospital. That's like it's equivalent to a life sentence, right? And as the facilities, they didn't have the capacity, the ability to restore him to competency, and the charges weren't dropped, right? So there's a process that if the charges are dropped, for instance, or they can decide to transfer. If the charges are dropped, there's a procedure to convert him to a civil commitment, right? A civil commitment. Uh, there's a process and there are rights that the defendant has. Well, they're no longer a defendant because a criminal case would go away. And this was one of the things that his attorneys was arguing. That's Frank Spencer was saying, look, that it violates equal protection of the law, because if he's only being committed because of he's been found incompetent to stand trial for this criminal charge, right? So he hasn't been convicted. But if he had been civilly committed, either as somebody who's feeble minded, right, has retardation, or somebody who is um, has suffers from a mental illness, right, he would have higher rights that would have to be observed, right? His rights would be, would be enhanced and they would have to be observed. He'd have more rights. But now he had no rights. They just committed him indefinitely and he wasn't receiving, there was no possibility for restoration. And it was like he was being given a life sentence, even though he had not been convicted of any crime. Unfortunately, this until this case, right? This was what used to happen, right? It happened in America that many people, instead of going through trials and being convicted, if they were found incompetent to stand trial, judges would just commit them indefinitely, and not just to a regular psychiatric hospital. They could put them in a maximum security place, some kind of maximum security psychiatric hospital where they're hardened criminals, even though they've never been convicted of a crime, and they could spend their entire lives there. Would be amount to a life sentence. So this was a cruelty, especially minorities were facing, many black men. However, this case, Jackson versus Indiana, changed everything. There was now a standard requirement that if someone's found incompetent to stand trial and they're committed to a facility, a psychiatric hospital, because of IST, there had to be a time limit, a definite time limit. But in any event, so what happened was, or they had to be released, right? Or they had to be released. So uh, um, there was an appeal that was made to the Indiana Supreme Court. The Indiana Supreme Court denied, right? And so they filed writ of certiorari. I've explained what a writ of certiorari is, all the way to the Supreme Court. That's just asking the Supreme Court to review a case because it implicates a constitutional right, right? So the Supreme Court granted, and eventually, they did rule in favor of Jackson. They did determine that that uh, a defendant who's been found incompetent to stand trial cannot be committed indefinitely, right? Just because of an IST, that it does violate equal protection of the law and due process, right? Because, the 14th Amendment is a very powerful law, right? It says, you're entitled to due process of the law. There's procedural uh, protection, and there's substantive law protection, that you have fundamental rights, right? They can't just deprive you of your life, your liberty, or your property, right? Indefinitely without due process of law. And due process of law means you're entitled to a defense, right? So they can't commit him involuntarily for an indefinite period. So they did find that it violates the due process of law, the 14th Amendment rights. Um, and one of the things that they did was they compared to the civil proceeding that, okay, if he had been gone through the process of being committed civilly, instead of being found incompetent to stand trial because of a criminal case, right? If he had gone through the civil process, he would have rights and he would be allowed to be released eventually, right, in a civil commitment, when the superintendent of the hospital, the facility, decides that, okay, his condition warrants release. That's in the case of being feeble-minded, right, or being retarded, right, or uh, if he's mentally ill, right, he could still be released by the superintendent when he decides that um, he has been cured or his competency has been restored, as the case may be. He's cured, then, but at some point he's got to be released. If he's in a civil commitment, they can't just hold him indefinitely. And up until this case, people who were institutionalized, kept in a psychiatric hospital simply because they were found incompetent to stand trial. Sometimes they could be held indefinitely. And so the Supreme Court said it was unconstitutional. It violates the 14th Amendment, equal protection of the law, and due process as well. And, and also that it would constitute cruel and unusual punishment as well. Now, there's another thing, there's another matter, another issue in which the court was moot on. That's with regard to the disposition of the charges, right? So the court didn't decide on the disposition of the charges because the court said, well, uh, it hadn't been determined his responsibility for his level of his culpability for the criminal charges had not yet been decided, and they didn't rule on that, on how to dispose of the charges. So I've done videos explaining criminal law. So in criminal law in America, in common law, in criminal law under the U.S. common law, uh, there are two things that are required that have to be present for someone to be guilty of a crime. They have to have not just actus reus. Actus reus is the action, right? It's the criminal action or the physical act or the criminal action. For instance, if somebody is guilty of a battery, right? They hit someone, so that's the actus reus. But the other part is that has to be present is the element of mens rea. That means they had the culpable mind, guilty mind. So they planned the they had intent. The layman calls it intent. So they planned the crime. They knew of the crime. They planned to actually commit a crime. So that's mens rea. So and that the guilty mind has to be there present at the time the crime was committed, not their mental state after. So that's another reason the court decided not to rule on that because there hadn't been a determination of the facts, how his mental state was at the time of the crime. So they didn't rule on that. So that's still up in the air. I might do a video and just expound on that aspect later on. But importantly, the court determined that somebody found incompetent to stand trial and who's been committed to a psychiatric hospital for restoration, they can't be committed indefinitely, right? It's a violation of the 14th Amendment. There has to be a time limit, right? There has to be a time limit. They can't just be held indefinitely. It will constitute cruel and unusual punishment, and it will be a violation of equal protection and due process of the law. And so that's what Jackson versus um, Indiana gave us. And this was decided on June the 2nd, 1972. I'll stop here and do more videos regarding mental health law. My name is Osha, and I'll keep you posted. Thank you.